Well, it looks as if the numbers of participants is leveling off, so we may as well begin because ultimately I don't want to keep you too long on this lovely sunny afternoon that we're actually experiencing for a change. If I could start with an apology. Unfortunately, yesterday I was called to court in the afternoon at the last minute, and unfortunately we've had some technical issues in Chambers, which has meant that the email that was due to be sent out to all attendees to warn them of the fact that yesterday's webinar was cancelled and it was being moved through to today, unfortunately didn't reach the majority of attendees. I'm very happy to see that so many of you have had the spare time to be able to join me this afternoon. But of course, if you haven't been able to join this webinar live and you do have any questions and you've not been able to partake in the Q&A, please do send an email into us at Chambers, and I will endeavour to respond personally to any emails that we receive in regards to this webinar. As with all of the webinars in the Goldsmith Chambers series, please use the Q&A box, which will appear at the bottom of your screen, if you have any questions throughout the webinar, and I'll hopefully have some time of about 5 minutes at the end of the webinar to answer any of those questions that you have. So, ultimately, in today's webinar, we've got an awful lot to get through. So without any further ado, we'll crack straight on into it. Now, as the majority of you will be aware, the aim of a party bringing proceedings in the civil court is usually to obtain a remedy to their particular problem or dispute. And in the vast majority of cases, that will be in order to recover money, recover property, or recover possessions. However, the court entering a judgment in the favour of the claimant or a creditor does not automatically provide that litigant with the remedy that they would have been seeking when they initially started the proceeding. It's as a result of this that the courts have a very wide range of enforcement powers to ensure that the parties comply with orders throughout the course of the proceeding, and most importantly, the judgments themselves when they are made at the end of the proceedings. A judgment creditor can choose whichever enforcement method appears to them to be the best method to use in particular circumstances. And most importantly as well, one method of enforcement can be used whilst other methods of enforcement are also being explored and used at the same time. However, it's particularly important to note that a court will not automatically enforce any judgment or order, and the onus is always on the party with the benefit of the judgment or order to then go ahead and take the next step to take enforcement action. Before enforcement action can be attempted, the judgment debtor is usually given the opportunity to provide the appropriate remedy, be that return a particular good or pay a sum of money under a money judgment. When the time set by the court for providing the remedy has passed, or an instalment due under some form of repayment instalment scheme has been missed, the judgment creditor will then be able to apply to the court for one of the enforcement methods that they would have available. It is therefore very important for litigators and their clients to check regularly whether payments due under any form of money judgment, and in particular instalments, are being adhered to. The court has the power to determine when a money judgment should be paid and how a money judgment should be paid. And that includes making orders for the payment by instalment. A judgment takes effect from the date in which it's given, and usually court will give a time period of 14 days for any remedies to be imposed. But ultimately, it is within the powers of the court to determine when a particular remedy has to be complied with. Looking specifically, for example, at cost orders, when those are made, the time for paying such cost orders is outlined within CPR 45, and that's been given as 14 days. Under CPR 40.4, a party with the benefit of a judgment should ensure that their opponent is served with a copy of that judgment, either by serving it themselves or through the court serving a copy of that judgment. However, it's important to note that it's generally not necessary to show that the judgment debtor has been served with a copy of the judgment before you then go ahead to attempt to enforce the judgment itself. So a case may well need to be transferred from the county court to the High Court, or from the High Court back down to the county court, before you can even start considering enforcement. A county court claim will have to be transferred up to the High Court if the enforcement by taking control of goods is sought on a judgment which is more than £5,000, or enforcement of a charging order for sale is sought where the amount owed is more than £350,000. On the other hand, a High Court claim will have to be transferred to the county court if enforcement by taking control of goods is sought of a judgment which is below the value of £600, a charging order is sought for a judgment of less than £5,000, or an attachment of earnings order is sought. And now I've put that specifically onto the slide as a separate bullet point because it's very important to remember that fact that an attachment of earnings order can only be sought in the county court. Therefore, you will note ultimately the procedures in both the High Court and the County Court are broadly similar, other than the fact that you can only get that attachment of earnings inside of the County Court. County Court enforcements must be made at the County Court Hearing Centre serving the address where the judgment debtor resides or carried on a business. If the judgment creditor wishes to apply for information from a debtor, a third-party debt order, or a judgment summons, they have to go to that local county court. However, county court charging order applications and attachment of earnings applications instead are made to the county court money claim centre rather than to the individual local county court. So it's important to check that you are filing applications at the correct location. Now, there's different teams that conduct enforcement on behalf of the High Court and the County Court. In the High Court, as you see on the slide, it's conducted by the High Court enforcement officers. And in the County Court, it's conducted by the County Court bailiffs. So let's consider for a moment what happens if you're in the position where you are the one that is required to pay a debt under a judgment. Well, ultimately, a judgment debtor who is unable to pay a money judgment or order is able to apply to the court for a stay of execution under CPR 83.7. So that's in regard to money judgment specifically. However, a claim can be for any period and on any terms as the court determines to be appropriate in the circumstances. Consider, on the other hand, CPR 40.8, where it creates a very similar power to stay an execution of non-money judgments which have been made. But that can only be done on the basis that events have occurred since the date of judgment itself. On the slide there, I specifically highlighted the case of Hall and another and Elia and another, in which the court considered it was necessary for the applicants to show a material change of circumstances when making repeated applications for a stay of execution. Now, under CPR 40.9, it's also possible for each side to apply to the court to vary the date for payment or convert a judgment into an order to pay by instalments rather than the full amount if they chose to do so. Such applications are required to be supported by written evidence outlining the grounds which are relied upon for that application to vary and include a full statement of the debtor's means, in particular when the debtor is applying for that application to vary the order. Under CPR 70.6, if a judgment or order is set aside by a debtor, any enforcement of the judgment or order shall cease to have effect unless the court orders otherwise. So that's something in particular to pay attention to if you find out that the other side are going to be applying to set aside. You may well take the view of, well, there's no point us trying to enforce this order yet until the application to set aside itself is determined, so that way you avoid expending too many fees. Filing an application for permission to appeal against a judgment will not automatically operate as a stay of any order or decision of the lower court unless the appeal court specifically orders otherwise. Therefore, the judgment debtor in those circumstances would have to consider whether they should apply for a stay to prevent the enforcement of the lower court order before the appeal is then heard. In most cases, the court must be satisfied that the appellant has a real prospect of success before it will be willing to consider staying the order of the lower court. The court is more likely to grant a stay if the appellant can show that the enforcement of the lower court's decision would defeat the benefit of a successful appeal. So ultimately, if the appeal itself is going to overturn the judgment which you are attempting to enforce, the court is more likely to grant a stay in those circumstances. So let's move on then to consider the individual mechanisms that there are for enforcing different types of judgment. And we'll start by focusing on money judgment specifically. The first question when deciding whether to enforce a money judgment against a debtor will be about whether the debtor actually has any assets available in which a judgment can be enforced against. Where little is known about a judgment debtor's finances, an application can be made to obtain information from the judgment debtor themselves. This requires the debtor to attend court on a set date and set time to be questioned in order to establish their financial status. And they'll be asked a wide number of questions dealing specifically with their names, their addresses, for any properties that they hold, any account numbers that they have, and then the details of any policies that they hold as well. In order to submit such an application, you would use the form N316. And in the form itself, it's important that you must state whether the application needs to be heard before a judge, or if there are any specific documents that you wish to see, that the debtor would be required to go to court. It's ultimately your choice after submitting such an application as to whether the judgment creditor or a representative wishes to attend the questioning, to ask any additional questions or obtain the information firsthand. Otherwise, the court officer will send a copy of the question form to the creditor after the debtor has attended. Now, there are other mechanisms which are available to you if you are unable to obtain information from the debtor. Well, the first thing you can ultimately do, of course, is ask the judgment debtor themselves for additional information about their means and finances. As often, the judgment debtor, if they're a large company, will provide that information to you in order to avoid the cost of being required to attend court for questioning. Another option is instructing an inquiry agent. Now, this is the newer term for private investigators. The risk of using such an inquiry agent is that you have to ensure that they are registered and that they are acting legally. And ultimately, you will hold final responsibility if they are not found to be acting in line with their registration or legally. You can also check the insolvency register. So if the debtor is bankrupt, you're unlikely to be able to enforce the money judgment against them. So checking first whether they appear on the insolvency register can save you a lot of time and money. Likewise, you can check the land register to find out what properties are owned by the debtor. And if they provide an address for a property, most importantly, you can confirm that the debtor is the legal owner of that property before you start trying to obtain things like charging orders. You can also check the attachment of earnings index, which will highlight any other attachment of earnings orders which have already been made against the debtor. The more attachment of earnings orders that are made against the debtor, the more unlikely it is that you're going to be able to obtain the judgment against them. You can check the register of judgments, orders and fines for England and Wales. Again, the more debts that they have, the less likely it is that they're going to be able to pay off your debt. You can check Companies House for the basic information about companies. If the debtor is a company, it will also be able to flag up to you if there's any ongoing insolvency proceedings. You can also ask around third parties within the same sector. You'll have to be aware, of course, that many third parties will be unwilling to share data and information that they hold on other parties as a result of data protection legislation. You can apply for an order for disclosure from a third party. In the case of North Shore Ventures Limited from 2011, the High Court confirmed that the court has jurisdiction to make an order for non-party disclosure after judgments has been given, so specifically in relation to a company's finances. However, it's important to note that it's a particularly high threshold test under CPR 31.17 that you would need to satisfy the court. And then finally, of course, you can check the internet, media outlets, and other research sources. In particular, if the debtor is a large company which is facing financial difficulties, it's likely that there's going to be some significant media interest. So what do you do in the circumstances where there's particular concerns that you have about a debtor? Well, if the creditor has concerns that the debtor is going to attempt to dissipate their assets that could have been used to satisfy that judgment, then the creditor's going to have to act very quickly. Under CPR 25, the creditor may wish to apply for an order for the detention, custody, or preservation of relevant property, a freezing injunction, or an order requiring a party to provide information about the location of relevant property or assets, which may well then become the subject of a freezing injunction. So going back to that last slide about how you would obtain information from a debtor. Now, if the creditor has fears that a debtor may try to leave the UK in order to avoid paying the debt, they can apply for a passport order, which is where the debtor is required to hand in their passport to the court. And that can be applied for under CPR 37. If a debtor becomes insolvent before the judgment is enforced, and the creditor is not a secured creditor, the creditor's debts will rank alongside other unsecured creditors in an insolvency, behind things like preferential payments, winding up expenses, and secured creditors. So if you find out that a debtor is going to become insolvent, you really are going to have to act quickly in circumstances to secure your debt against that debtor. So the different options for enforcing a money judgment are outlined in Practice Direction 70, and specifically in Practice Direction 70.11 and 70.12. The first and arguably one of the most popular methods of enforcing a money judgment is taking control of goods. And you can see that on the slide that I've highlighted a multitude of TV programs that there are at the moment, all to do with High Court enforcement officers and county court bailiffs, which are actually quite good from a civil litigator's at showing how enforcement actually operates. So in order to take control of goods, it requires a writ of control or warrant of control, which commands an enforcement agent to take control of and sell a judgment debtor's goods in order to raise funds to satisfy the judgment debt. Taking control of the goods involves securing the goods on the premises in which the goods were found, securing those goods on a public highway, removing the goods from the premises and then securing them elsewhere, or entering into a controlled goods agreement. Now, a controlled goods agreement, very briefly, is where the enforcement agent will enter into an agreement with the debtor that the debtor can keep hold of the goods as long as the debt which is outstanding is then paid by installments, as per the agreement between the two parties. Before taking control of the debtor's goods, the enforcement agent must serve the debtor a notice of enforcement in the prescribed form at least 7 days before the enforcement is due to take place. Enforcement writs and warrants are valid for a period of 12 months from the date in which they are made, and taking control of goods can be done at any time on any day, as long as it's done between 6 a.m. and 9 p.m. So it doesn't matter if you're attempting to enforce an order on a weekend. Unless the goods are on the highway, the enforcement agent may not take control of goods where the aggregate value of those goods is more than the value of the debt. So it's not a case of that they can collect as much as they can from the property, sell it all, pay off the debt. Instead, they can only seize the number of goods that they believe will get them to that grand total of the debt. The goods that are seized must not be exempt goods. And by that, we mean those that do not belong to the judgment debtor, usually referred to third-party goods, those that are not in the place where the debtor lives or works, and then those that are deemed to be specifically exempt goods. Now, those specifically exempt goods under the statute are those that are used personally by the debtor in the course of his employment. So, for example, if he's a self-employed plumber, you wouldn't be able to remove all of his tools. Those provisions that are reasonably required to satisfy the basic domestic needs of the debtor and their household. So by that, we mean things like clothing, bedding, particular items of furniture like beds and sofas. Additionally, assistant dogs and vehicles displaying a disabled person's badge could not be removed by an enforcement officer, and also goods which in of themselves constitute somebody's homes, things like houseboats and caravans as well. So the next mechanism which is available are third-party debt orders. By third-party debt orders, sums owed to a judgment debtor that are in the hands of a third party, usually banks, are frozen and seized for the benefit of the judgment creditor, rather than then being paid across to the judgment debtor. Such orders are useful where the judgment creditor knows that the judgment debtor has a bank account into which things like their wages and salary are being paid into. So it's an account which is likely to have a fair amount of money in it. Such applications are formed of two parts. The first part is where the creditor has to make a without notice application for an interim third-party debt order. In order to do that, they would use the form N349, and that would have the effect of freezing the money in the account whilst the court then arranges for the second stage, which is an oral hearing, which can be attended by both the debtor and the creditor, and the court will make the final determination as to what should happen with that frozen money, and whether the money itself should be unfrozen and paid back to the debtor. A third-party debt order may be refused by the court if it would be inequitable to grant it. And usually that would be in circumstances where the third party who have had that money frozen would effectively end up having to pay the money out twice, or circumstances where the debtor is insolvent. The next money judgment enforcement option is a charging order. A charging order is a way of securing a judgment debt by imposing a charge over a judgment debtor's beneficial interest in land, securities, or certain other assets. This usually has the effect of preventing the judgment debtor from selling the land without paying what is owed to the judgment creditor, provided that there is enough equity after payment to prior creditors. And it's important to remember that on most properties, you will have a mortgage lender as being one of the first creditors that will have a registered charge on a property. And so you need to make sure that once the mortgage is removed, there's then enough equity left over in that property for you to then be able to pay off the debt. The charging order is most effective when there's substantial equity within the property and the judgment debtor themselves is the sole owner of the property. So that, going back to what we said earlier, is when you would use the land register to double check that information. Unfortunately, the process for obtaining a charging order can be particularly slow, and a charging order in of itself does not automatically release funds to satisfy the judgment debt, as that requires either a sale of the property by the owners, or you would need to apply for an order for sale. It's important to note as well that the court may not choose to secure a small judgment via a charging order when this could be enforced by other methods. So usually the court would wish to see that it's a substantial sum which you are seeking to enforce by way of charging order before they will go ahead and grant that charging order. Now, one of the most commonly used methods of enforcement is an attachment of earnings order, which provides that a proportion of a judgment debtor's earnings is deducted by his or her employer at source and is then paid to the judgment creditor until that judgment debt is paid. The basis of deduction is guided by set rates and applied to the judgment debtor's resources. This method of enforcement, as we keep mentioning, is only available in the county court and cannot be obtained from the High Court. An attachment of earnings order cannot be made in respect of self-employed income, state pensions, benefits, or state allowances. Provided the debtor is employed, the judge will first of all have to consider the debtor's income and expenditure, and then they will fix two different rates. The first will be the fixed protected earnings rate, which is the fixed sum from which no deductions can be made, and that will go towards the debtor's general living expenses for them and their immediate family. The second sum will then be the deduction rate itself, and it's from that deduction rate that the deduction can then be made and paid across to the creditor. Attachments of earnings are a particularly popular method of enforcement as they're fairly inexpensive, they're fairly easy to do, and most importantly, the automatic deduction from wages means that you don't actually have to rely on the debtor themselves paying the money across to you. It's all done automatically. However, things to bear in mind are that it depends on the judgment debtor being consistently in employment, and it can take a long time to pay off judgment debts. Indeed, I once had a judge explain it to me by using the comment, effectively you're going to get pocket money for the rest of your life. So usually it's not significant sums that you'll be able to receive on a monthly basis through attachment earnings. Looking incredibly briefly at insolvency, and it is explained in a bit more detail inside of the practice note, which will be available after this webinar. If the amount you are owed by an individual judgment debtor is £5,000 or more, you can apply to make him or her bankrupt. You can also apply for a company to be wound up if that company owes you more than £750. After a bankruptcy or winding up order is made, the judgment debtor's assets will then be collected by either a trustee in bankruptcy or liquidator and will then be distributed among all the creditors in accordance with insolvency law. So you would need to double check the position in the queue that you would hold as one of those creditors following such an order. However, it's important to note that this procedure can be expensive and is usually incredibly time-consuming, and it could ultimately lead to the situation where you find that there's no money left in that pot for you to be able to recover the judgment debt. The threat of insolvency can sometimes lead to the judgment debtor suddenly panicking and making a payment of the judgment debt to you. However, the courts have been very clear that they discourage the use of insolvency procedures as a way of collecting a debt specifically. Also, very briefly, a judgment summons is a procedure for punishing or defaulting a debtor who could pay a judgment sum but has chosen not to, and the court imposes a period of imprisonment on them. Since the Administration of Justice Act 1970 came into force, however, judgment summonses have only been available for enforcing matrimonial maintenance orders and payment of arrears of some taxes. So we've definitely moved very far away now from the Dickensian view of debtors' prisons. Additionally, the court can make an order committing the judgment debtor to prison for contempt of court if he or she does not comply with certain types of orders. And the process and procedure for that is outlined within CPR 81 and Practice Direction 81. Now, as we mentioned earlier, the reason as to why that's been mentioned as an enforcement method is because all orders requiring the judgment debtor to provide information that we discussed earlier under CPR 71 are often accompanied by committal orders providing that they come to court or they will be imprisoned if they fail to go to court in order to answer those questions. Therefore, both of these methods are not strictly speaking enforcement methods, but rather sanctions for failing to comply with judgments which have been imposed by the court. So moving on from looking specifically at the enforcement of money judgment, we can move on to consider the enforcement of judgments for the delivery of goods. Enforcement of judgments for the delivery of goods is done by means of warrant of delivery. A warrant of specific delivery requires an enforcement officer to seize the goods which have been specified within the judgment with no alternative of obtaining a monetary amount for the goods instead. A warrant of delivery which is made on a general basis requires the enforcement officer to seize either the specific goods within the judgment or they are able to accept a monetary value amount for the goods instead. So I had a case a few weeks ago where a gentleman was trying to get recovery back of a very specific motorbike, and he hadn't been paid the sum by the debtor for that motorbike. The reason he specifically wanted a warrant of specific delivery is because it was a particularly rare motorbike, in particular in the UK, where there are only about 5 of that particular type of bike on the roads in the UK. Therefore, to him, getting a monetary amount for that motorbike just wouldn't have had the same effect on him. Now, the procedure to be followed is pretty much the same as the procedure for an enforcement of a money judgment by taking control of goods. In particular, the enforcement officers being required to give the statutory 7 days notice before they attempt to carry out the enforcement. Moving on then to consider enforcement of judgments for the delivery of land. Permission from the court is required to issue a warrant of possession unless the claim is specifically against trespass. Permission will not be granted unless every person in the property is given notice of the preceding possession and given the opportunity to apply for relief. So usually there will be a set time limit for the occupiers of the property to respond to the impending eviction. Entry to a property can be obtained by the police if necessary, and generally the claimant or creditor who is taking possession back of the property is strongly encouraged to attend the property themselves in order to secure it after possession has been obtained. There's a bit of a difference in the High Court and in the County Court. In the High Court, any goods which are inside of the premises must be removed by the enforcement officers when they are carrying out the eviction of the property itself. However, for County Court bailiffs, they are not then required to do this step. So it's something to bear in mind when considering to go down the High Court enforcement officer or County Court bailiff route. Now, in the very rare situation where the occupier returns to the property after possession has already been obtained, the individual who's moved back in can be removed by the use of either a warrant or writ of restitution. The application is made without giving notice, but the application itself will need to give details of the wrongful re-entry, and all you would need to ultimately do is satisfy the court that there's a clear nexus between the original recovery of the land and then whoever it is moving back into the property itself. Now, very briefly, as I know that we've already gone over time, let's take a look at the enforcement of foreign judgments within the United Kingdom. Well, at common law, a foreign judgment can be enforced in England and Wales by bringing an action under English law claiming the amount of the judgment as a debt. The way that it would work is that effectively the foreign judgment would give rise to an implied contract to pay whatever that debt amount sum is, and you would then be able to enforce that debt under English law. The UK is party to a number of international conventions and statutes providing for the direct enforcement of foreign judgments, and those have been incorporated into English law. And you can see that I've outlined the key ones on that slide there. Of course, the important thing to bear in mind is Brexit negotiations are still ongoing. We don't know yet what the position in regards to all of this legislation is going to be once the Brexit process has been concluded. So, of course, I've now set out for you what the general process of enforcement is and the different enforcement methods that will be available to you usually. Now, as those of you that have been watching our previous webinars in this series will be aware, COVID-19 has produced a lot of restrictions on enforcement actions. So the Coronavirus Act 2020, which we've spoken about many times previously, came into force, of course, on the 26th of March 2020. And it in particular had a direct impact on attempts to obtain possession of private properties. And it was imposed in order to try and protect the public by keeping people in their homes and not making people homeless or having people moving around during the period of lockdown. As you'll all by now be very well aware, additionally, CPR Practice Direction 51Z2 calls all proceedings seeking to enforce an order for possession by warrant or writ of possession to be stayed for 90 days from the 27th of March 2020. CPR Practice Direction 51Z2A then further clarified that the restrictions imposed by that practice direction do not apply to claims against trespassers, applications for interim possession, or applications for agreed case management directions. Now, most importantly, as far as we're concerned, when we're talking about enforcement, the Taking Control of Goods and Certification of Enforcement Agents Amendment, Coronavirus Regulations 2020, which we've discussed previously in a few of our previous webinars, imposed temporary restrictions on enforcement by creditors, including the prevention of enforcement agents taking control of goods at residential premises or on highways whilst there are restrictions in place preventing people from leaving the place in which they live without a reasonable excuse. Therefore, neither the enforcement of money judgment through taking control of goods, the enforcement of possession of either land or goods can ultimately take place at the moment whilst enforcement agents are unable to work. Considering some of the other enforcement methods that we've already discussed, there do not appear to be any restrictions on applications being made to the court or any of the other civil enforcement methods. However, it's important to bear in mind that such applications, especially those that will end up with some form of oral hearing being required by the court, will be significantly delayed by the reduced number of judges and the lack of judicial sitting hours which are being caused by the present pandemic. The additional demand on court services will also mean that applications for orders for debtors to attend court to answer questions, there's going to be less court officers around to be able to arrange those appointments. So there is going to be generally a delay to enforcement action at the moment. Given the government's announcement yesterday, we're yet to find out whether they are going to now ease the restrictions on enforcement proceedings themselves. As the court will be giving preference to priority cases, an enforcement application has therefore a greater chance of currently being successful if the enforcement method does not require the court to have an oral hearing, and it doesn't need to be enforced by the courts themselves. So effectively, that means that attachment of earnings orders suddenly are becoming the most important form of enforcement that you have. Very careful consideration is now going to need to be taken by litigators, looking at all of the circumstances of the specific case in which the creditor is trying to obtain a debt from a debtor, and the wider circumstances regarding the restrictions to the court and enforcement agent, in order to determine which enforcement option is going to be the best option for the particular creditor. So, thank you very much for staying with me. We have overrun by some time. Up on the slide there, as always, you do have our contact information for our two clerks, Ben Cresley and Alice Martin. And Ben Cresley's email address has been provided if you have any questions about this webinar or any of the other webinars that we've had in the series. So I did say that I would try and answer some questions. So I'm just quickly taking a look at the questions that we've had. Okay, so we'll try and take them in order. Is transfer from the High Court to County Court automatic, or do you have to pay a fee like the other way round? It's believed that it is an automatic process and you wouldn't have to pay an additional fee in those circumstances because you're specifically barred by statute from enforcing in the High Court. If you attempted to enforce in the High Court in those circumstances, the High Court themselves are highly likely to automatically transfer it down to the County Court for you. As is noted within that question itself, in circumstances where you have a county court order for possession, as we discussed back in the residential possession proceedings webinar, you attempted to get enforcement transferred to the High Court under Section 42. In those circumstances, you do specifically have to pay an additional fee because the court's having to do more work that it wouldn't otherwise expect to do. Next one. So if you're dealing with two or more issues, such as seeking for remedy or damages and property or criminal issues, would both claims be considered at once in court, or would a different complaint or cases need to be filed? Oh, now that is a difficult question because ultimately it depends on the specific situation that you are dealing with. I wouldn't be able to answer that directly here now, but please do send an email into Chambers and our civil clerk will be more than happy to assist you based on the specific circumstances that has risen to that question. Has any judgment from these courts gone or could go to judicial review? Unfortunately, I'm not sure now specifically what that question is in response to. So again, I would urge you to send an email into us at Chambers and we'll be able to answer that. And this might be more of an insolvency question, but just in case you know, if someone was facing a bankruptcy with a number of creditors, but prior to hearing of the petition, they paid each creditor just enough so individually none of the creditors were owed more than £5,000, could the petition still go ahead if the cumulative debt crossed the threshold? Oh, now that is a very interesting question. And unfortunately, I'm going to have to take the view of I'm going to need to look at that myself. So leave that with me. I've taken a note as to who it is who's sent in that question, and I'll email you after today's webinar once I've been able to look into that issue more specifically. So it appears that that's all of the questions that we have at the moment. So thank you ever so much, everyone, for joining me. Of course, as with all of the webinars as part of this series, the slides from today, a copy of this video itself, and my practice note will all be uploaded to the Chambers website in the news section in due course. If you do have any questions upon receiving any of that information, please do get in contact with us via the email address on that slide. Additionally, a copy of the video will go up onto YouTube in the Goldsmith Chambers YouTube account. So just type in Goldsmith Chambers and you'll find not only this webinar, but all of the ones that we've had in our series. The next webinar that we have is tomorrow at 3 o'clock, and that's procedural issues and the role of experts in immigration proceedings. It will be led by Bronwyn Jones. And then on Friday, we have applications under FTR Part 25 from the family team, again at 3 o'clock. And as with all of the webinars in this series, you can sign up for those if you're interested using the Eventbrite page. Now, unfortunately, this is currently the last civil team webinar that we have listed. So we're now moving on to a fairly new format where instead of us coming up with the idea for the webinars, we would encourage you to get in contact with us directly. If you have any particular topics that you would like some further information on, or if you think that there's a webinar that would particularly benefit you as a firm directly. If that applies to you, please do get in contact with us using the contact details which are outlined on that slide. Therefore, on behalf of the civil team, I thank you ever so much for joining me, not only today, but in all of the previous webinars that we've done. And I wish you a very pleasant afternoon.